Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
So, okay, why don't you head over to
Washington. Wow,
yeah.
this is a developing story. When I first posted about it, excuse me, when I first posted about it, a fire district in Washington, the Benton County Fire District #1, was scheduling a disciplinary hearing for a firefighter who had a pending sexual harassment lawsuit against the district. She was apparently out on maternity leave. While she was out on maternity leave, she filed the lawsuit based on harassment, and she had done all the things that she was supposed to do as predicates to that. But while she was off, while she was off, she filed a lawsuit. When she came back, they immediately put her on administrative leave pending disciplinary action. And so now she's facing disciplinary action. And this was, what was it? It was last week. And August 29th. And so that was, when I posted it, that was sort of the end of it, that this hearing was supposed to happen on August 29th. Well, August 29th happened and she got fired. And so now she's been terminated. And I would imagine now she is going to be alleging retaliation for having filed a sexual harassment suit. And, I think there's two ways that we could look at this. One way is that once someone sued us, we've got to be very careful about how we handle her so that we don't find ourselves in a situation that looks like retaliation, which is what we're in here. And so that's sort of kind of one aspect of it. But let's kind of go with another aspect where maybe we got a problem employee. And certainly I'm not suggesting that we have a problem employee here, but but where we have a problem employee, and one of the things that they choose to do now, because they're recognizing that sort of the gig is up, so they file a sexual harassment lawsuit. And they did something for which possibly they could be disciplined for, but then in sort of a preemptory move, they filed a lawsuit. They're off, and now they come back, and we should have disciplined them before, but they were off, so we waited, and now it looks like retaliation. So I'm again, tale of two cities here. I'm not sure which of the two is the accurate one. Do we have a problem employee? Do we have a department that's retaliating against a good employee? It could be both. It could be both. But it's very difficult once someone has filed a lawsuit, unless you've got your ducks in a row. And we have seen departments that do, Denver, and, one of the next cases, we're going to talk about it, but it's very difficult. You got to be very careful about allegations of retaliation.
Look, and the standard is so simple, right? You must have a actual, legitimate, 100% independent basis for terminating somebody that has nothing to do with their alleged claim of discrimination, etc. So let's take the hard case. You have somebody who says the chief made sexual advances to me, all right, and I'm suing the chief and the department because I complained about it and nothing's ever happened. But since then, you develop let's call it a piss poor attitude. By the way, nothing has anything to do with this case, right?
Right, just hypothetically, right? No, hypothetically.
So, but then the employee develops a piss poor attitude and refuses to do their job, right? Well, I'm so mad I'm not cleaning. I'm so mad I'm doing this. I'm so mad I'm doing that. And then they're terminated as a result of their failure or refusal to do their job. They're terminated. And then they go out and claim, well, you discriminated against me because I complained. And we're saying, no, we were hearing your discrimination claim. Hopefully we were dealing with that and remedying that, but then you did all these other things. So I find that so common because this month I'll be a little less specific. I have that exact issue. And you know, the first question a lawyer should have for his clients are, do you have an independent, unrelated reason for the termination or discipline, or are you just trying to get back at the person? And if you have 1 or 2 or 3 things that in your policy manual, it says, if you do this, you can be terminated. And in fact, you've maybe terminated other people. You've treated them the same way, no harsher than this person. You should be okay. But you and I, and probably a lot of attorneys like us, get constant calls, I'm sure, that says, oh my God, we have somebody who we want to fire, but now they're screaming disability or race or gender or age or whatever. Mm-hmm. And my first question is, let me see the paperwork. What time, date, and place did they do something wrong where you told them you can't do this? What policy did they violate? What's the proof, right? What's your independent reason?
Right.